Special meeting held on Thursday, January 15th, 2026 is called to order at 9:11. Do I have a motion to approve the agenda?
I move that we approve the agenda.
I second.
Second, all in favor?
You're not interrupting
Aye.
anything, we're trying to get set up. so.
Opposed? Okay, our board clerk
Leave it for
Jennifer
John.
Sippy will lead us in the flag salute.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Does this one need a power cord?
It's fully charged.
Oh, okay.
Rochelle, in a couple hours, there's a power cord in my office.
Oh, okay. Okay, well, get started here then. Good morning, all of you. On this morning's entertainment, so. We're going to be talking today, of course, about the Brown Act and about ethics for local officials. So, this is our agenda for the topics we'll cover today. First, the Brown Act. We'll go through a brief overview of the Brown Act, kind of just the structural composition of it. Then the basic meeting requirements, because the Brown Act basically revolves around the agendas. I'm sure you all have already figured out, even if you're new to this. And then there's some other provisions, obviously, such as when can you go into closed session and all of those things. We'll talk about teleconferencing, which is the hot new topic. Did Erica email you the new teleconferencing document?
Yes,
Is it
they have it.
Oh, good, okay. Yeah, because we had to revise this because of the new statute that came down last year that revised some of those provisions. The legislature just can't help itself tinkering with this stuff. And then we'll talk about agendas, because as I say, that's really the heart of the Brown Act. It's not on the agenda. Very rarely can you do anything with a topic in a particular meeting. And we'll talk about when you can go into closed session. There's about 6 major reasons why a board like this would be willing to or need to do that. And then I have questions on that topic. Now, of course, I do encourage you to ask questions as we go along, although we only have 2 hours. So, we still have a whole other topic then after that, which is conflicts of interest. First, talk about, again, an overview of the topic. Government Code 1090, which is the most significant of the statutes that govern conflicts of interest. The Political Reform Act, and then there are several other ethical principles, things like not making a decision on something where you might have a personal bias, or in some cases, whether you might have personal relationships, like a family relationship with someone that you might be dealing with, and so on. Okay, so we'll start here. Brown Act, of course, it's the thing we're here for today. Brown Act was adopted in 1953 after Ralph Brown. I was going to say it was named out, it's along with California's Orange Act, Blue Act, Red Act, and Green Act, but of course that's not true. There are different explanations for why it was adopted. Some of the stories say that it was because Sacramento Bee did an investigation about government bodies at the local level meeting in secret and making decisions without anybody from the public being able to attend. That's the one thing I always like to tell, because of course the Sacramento Bee, as some of you probably are aware, when the bee sneezes, the legislature catches cold. So anytime there's some kind of a scandal in Sacramento, we all have to have new things we have to do. And the ethical training that you all have to take as board members is one of the things that's, for example, a requirement because of a Sacramento scandal there involving the water district. The story I've heard, though, is that Ralph Brown was an attorney, and one of the things he did, since it was a part-time legislature and everybody had to work basically to support themselves, he didn't make very much from being in the legislature. It's kind of like being on the school board, So Brown was a representative in labor matters for various unions, and he represented a nurses union in a hospital, and he met with the board members, and they agreed to some increases in pay and benefits and so forth. But then after he thought he had cut a deal with them, they met secretly reimburse themselves. And so because the secret backroom deal that he himself had cut didn't go through, he then decided, well, I'm going to show you. Hence the Brown Act. So, the original version of the Brown Act only had 686 words. Today, it has significantly more than that, somewhere between 25,000 and 29,000. I haven't run a word search since SB 707 came down, but I suspect it's probably over 30,000. It's just an enormous statute. Have you ever tried to stumble through it on your own? Just go to there's a great website, California Legislative Information, that has, I use that more than I probably use our pay-for one, because that one you just call it up and you can, the only thing you can't do is you can't click on one statute to move to a citation of another statute or one you're working with. So, but otherwise it's a really great tool, and it's free and it's online and so forth.
What's the name of the website?
It's called the California Legislative Information. The California Legislative Council's office puts that out there. And I just was there yesterday, and they have updated it now for some of the 2025 legislation. So they do keep doing a good job keeping it up to date too. So it's a very useful website. Okay, Government Code 54950 at C. So of course all the numbers sound the same. It's the state law that governs the conduct of meetings of school boards and other local bodies. It requires that you take all of your actions in public with a few narrowly screwed exceptions for closed session. It applies to legislative bodies of legislative public entities. You'll see that term used a lot with the Brown Act, legislative body. It's really kind of a misnomer. I mean, cities and counties are legislative bodies. They actually pass ordinances. You might remember when the paper bag law came in a few years ago. Before that, you could give plastic bags for free. Mendocino County, City of Ukiah, some of the other cities of Ukiah, Mendocino County adopted their own before the state law took effect. Willits would not. Willits is sort of, we're independent up here, so I used to come up here whenever I wanted paper plastic bags because you could go to like Grocery Outlet or Safeway and they could still give it to you. So again, they do pass local ordinances though that do have the force of law, just like the state legislature. School districts are not really legislative bodies in that sense. You pass regulations and policies for your own use, but you're not truly a legislative body. Nevertheless, that's what the statute calls all bodies that are subject to its, and even water districts and very mosquito abatement districts and so forth. All meetings shall be open to the public. That's an interesting point right there. I was in a meeting one time where a board member, because the public was getting a little unruly, and he said, I should remind you, this is a meeting of this board. We have to meet in public, and you have the right to make comments about certain things that go on at the meeting. But it is still a meeting of this board, and it is our meeting, essentially. So, because sometimes the public thinks that because they do have certain rights to participate, that they can sort of step in and run the meeting, and that's really not what even the Brown Act requires. So, meaningful and timely agenda, that's the big part of the Brown Act here. Closed sessions permitted in limited, narrowly construed situations. So generally, when it comes down to a question of, can you interpret this statute about a closed session matter to favor having the closed session or not, it usually means you have to tip in favor of not having a closed session. And then again, there are civil, and everybody knows about the criminal penalties for the Brown Act. They're actually very, very limited, but nevertheless, it's in there, and that's usually what gets everybody's attention. And again, members of the public, certain public officials can also sue to overturn decisions, and courts can impose fines and attorney's fees for people who bring challenges if they're successful. So that's really kind of the big check on what bodies do if they don't comply with the Brown Act. Okay, legislative bodies, school boards, personnel commissions, boards of joint powers authorities, charter school boards, college boards, college foundation boards, the academic senate, which is an organ of the community college, 7-Eleven committees. I don't know if you've ever had to panel a 7-Eleven committee. I hope you don't. It's a really onerous process. That's for, you want to dispose of surplus land. Even if you have a piece that you want to sell, you can't just sell it, find a buyer and sell it. You have to go through this process where you review all of your land and have this committee review it for you, and it's very time-consuming. Bond oversight committees, which of course is a newer one because of Prop 39 a few years ago. And then any body created by formal action in the Brown Act body is also a to, again, if you had 7 people, you could have 3. Anything less than a quorum, and they're limited to that one topic, then that's an ad hoc committee, and you do not have to go through the agenda posting. You can meet in your living room if you wanted to. But that's a very narrow exception. I've actually seen one-member committees sometimes. Yes, sir?
Yeah, I don't think of things like cemetery boards and that sort of thing, or they're volunteers, but that was when you say any body created by formal action of the Brown Act body.
Well, first of all,
You
if
can
the body is
clarify that.
created by state law,
Okay.
then it's automatically a Brown Act body. So you can find it in one of the codes. You have a community services district over here, Burke Trails, for instance. That's a Brown Act body because that was created under the government code regulates community services districts. Water districts are created by the water code and all those things. So all of those bodies, including school boards, are Brown Act bodies because they're established by state law. And then if this body were to create a body you have not had before, and it either has a majority of this board on it, or in most cases, like a planning commission where you just appoint other people from the community, if you create that through a minute order or resolution, then that becomes a Brown Act body by virtue of it having been appointed essentially by this body. So it's essentially that you created this subsidiary body to do work so that.
Specifically on
Yeah.
one topic, though.
Well, no, that's not the ad hoc.
Okay.
This is like if you created a permanent, I mean, for example, some districts have, like say a personnel commission, you know, and if you change the way that you do your labor negotiations and you didn't have one before, but you created one, then that would be a Brown Act body too, because it was created by formal action in this body. Ad hoc committees, though, are the exception. If you just say, okay, we need someone to study, what's the feasibility of going out for a bond on this topic, the chair appoints 2 people on this board, that's an ad hoc committee, so you don't have to have an agenda. So you could, but in most cases, it's usually more efficient not to go through that.
Okay, thank you.
Sure. Okay. All right, we have a lot of hypotheticals in here. The idea is you have them on your handout, but I didn't put the answers on there, so that way you can't just look down and see the answer. Right? Cheat. So, a board member establishes an advisory committee consisting of 3 students to advise her on important issues as they arise. Does the Brown Act apply to this committee? What say you all?
No,
Why not?
because they're not members of the board. These students are not members of the board.
Well, they're not. Now,
And there's only one more than.
exactly. That's the key here. The Brown Act does not apply to an individual decision. So if one of you decides to appoint your kind of own informal group to advise you like this, that would not be a Brown Act body because the board is not the one that decided to create this little mini committee board was. The individual board member was. And this is often the way that if you want to have a topic studied that you do not want the public to have the opportunity to sit in on, and again, this gets a little kind of technical here. If the superintendent were to do that, that also would not be a Brown Act body because again, one person cannot create a Brown Act commission. But if the board were to tell the superintendent, appoint 3 people to a commission to do such and such, that would be a Brown Act body because he's taking his direction from you, so it was your formal action that got the ball rolling there. So I know we're getting this inside baseball here already. That's the distinction. If one person just decides to do something, then that is not a Brown Act body because the full board did not weigh in on that.
So instead of 3 students, it's 3 adults?
Would make a difference. It's the person who makes the appointment or the nature of the appointer, that makes a difference about whether or not it's a Brown Act body. On behalf of the board president appoints a 2-person committee comprised of solely of board members with a limited purpose to recommend nominees to the bond oversight. This is quite common when you have a body that you need to have appointees to. Must the committee post an agenda and comply with the Brown Act?
Yes.
Well, in this case, the answer still is no.
There has to be, there's 3, right? There's
Well,
only
actually,
2?
yeah, the person doing the appointing here is the board president. That's the difference. If the board president makes an appointment, that does not normally constitute a Brown Act body. In addition, he's appointing 2 members of the board. That would be an ad hoc committee because it's with a very limited purpose of recommending nominations to the bond oversight committee. So as long as only 2 people from the board get together, that's normally not going to be a violation some bodies, I don't know, do you have standing committees? Yeah, I mean, for example, I worked for Mendocino County, they had 4 very carefully constructed committees. They had general government, land use, I don't know, there were 2 other topics, I think you might remember those days. Yeah, but the board did have standing committees, but they would meet on a regular basis, just like the board would. There's only 2 board members, but because they had a continuing jurisdiction, that was considered a Brown Act body. So the distinction is 2 things really, is it who appoints the people, and if it's a quorum of, less than a quorum of the board, they have ongoing jurisdiction, like a personnel committee, or only a one-time thing like this. A lot of school districts also have a curriculum committee to decide about new classes and so forth. So. Okay. Again, ad hoc committees comprise solely of less than a quorum of board members are exempt from the Brown Act, as long as they're not meeting regularly and having an ongoing topic that you cover. Okay. A meeting is any congregation of a majority of the members of the body at the same time and location to hear, discuss, deliberate, and take action on an item that is within the subject matter jurisdiction of the body. Okay, this is where we kind of get into these. This is one of the courts originally created this notion of a serial meeting, which means that it's, even though all 3 of you never gather in the same room, which again sounds sort of like what they say at the top there, right? Any congregation of a majority at the same time and location. Well, courts decided that wasn't restrictive enough. So they decided that if you talk outside of those kind of channels and more than a majority is involved, or at least a quorum of the board is involved, then that also constitutes a meeting of the body subject to the Brown Act. Okay. So this is sort of a little deviation here for a minute. A few years ago, they added this new statute, 54952.2, social media in the Brown Act, because it was getting more and more common for board members to be going on their own Facebook pages and so forth, and posting things about matters that were meaningful to the community. A majority shall not use a series of communications of any kind. That's the general restriction under the Brown Act. And even if A speaks to B, B speaks to C, and C speaks to D, that would be a meeting of the board, even though it is not again all congregating at one time. Allows you to communicate with community members using social media, Facebook, Twitter, whatever the Instagram, whatever your tool of choice is there. And you can provide information to the public. Again, this is what you do as a elected official, right? You meet with constituents and so forth. This is doing it in a more global sense. But for some reason, they seem to interpret this more narrowly than what you could do out in the field itself. I've never understood this. Prohibits the majority of the board members from using social media to discuss among themselves business of a specific nature within the subject matter. This is very much like that serial meeting rule. You may not respond directly to any communication in a social media posting regarding a matter within your jurisdiction. If it is made, posted, or shared by any other member, a like or a share also constitutes a Brown Act violation. So I guess when you go online, you have to use a fake name. But yeah, I mean, technically, and again, this is, it's more restrictive actually, because if you interpret it strictly, it seems to say that even if it's not a majority, that still could be a violation. I don't know that that's necessarily true. I think as long as there's no more than the, or no, it is not at least a quorum, then I think it might still be okay in that situation. But this has gotten to be a very hot topic because, for example, certain community members, I'm sure none of you have ever had this experience, would sort of pester and track and stalk various board members, and it got so bad down in the city of Poway in San Diego County, one of the board members blocked somebody, and the person sued saying it was a violation of their First Amendment right, and of course the court then came down squarely in the middle. I said, well, it could be. And there were a couple of other cases out there at the same time. So social media is kind of a viper's nest if you really get involved with it as a public official. Okay, and then what they did, this used to be, it was going to sunset at the end of last year. One of the things they did with that last year's SB 707 was they got rid of the sunset, and so this is now a permanent part of the Brown Act. And okay. Open and public meetings. And again, these are the 4 kinds of meetings that you can have as board members. Regular meetings, of course, once a year you sit down as a group, you plan your schedule for the following year. Most boards typically do this at their December organizational meeting. And technically, technically is not required under that statute that you have your regular meeting schedule set, but for most boards, that's the most convenient time to do that, because you're usually all gonna be there, and you all have your calendars out, and you can figure out, okay, when are we gonna have our regular meetings? You probably have it on a regular schedule, correct? A certain day a month, yeah. Tuesdays, I guess, are usually the most popular, but it depends on the board. You have special meetings, which can be called by the presiding officer or a majority of the body, which you actually can confer, I think, informally, just to decide we're gonna have a special meeting. That's not really a congregation that would violate crime, because all you're doing is scheduling, you're not really making a decision about anything. Again, this is typically for only discrete items, although you could have very many items on a special meeting agenda. Yes, sir.
Okay, say for example, you're negotiating with a union and you want to get together to discuss the terms of the contract and possibly vote in favor of accepting the terms or whatnot. Is that something, you know, that sort of thing would qualify as a special meeting?
It could, what basically means like you'll have a regular meeting schedule, like the second Tuesday of every month, and then there's something you need to do before the next regular meeting. And so you say, hey, we need to have a meeting on Thursday afternoon. And so, again, the chair normally is the one who's empowered to call those, and I mean, call every other board member and say, hey, we're gonna have a special meeting on Thursday afternoon, and the superintendent can do that, and that's perfectly okay.
But would you have to, would you publish an agenda?
Oh, yeah, you have to post an agenda. The difference is a special meeting only requires 24 hours notice, and you're limited to what's on that agenda. You cannot take personal off-agenda items.
But in our circumstances, our superintendent is the one that works with the board itself does not have that. So that
Right.
wouldn't be an issue because he's already worked with his.
Well, I can envision, that might not be the best example. One thing, my boss knows about this better than I do because she's our labor person, but there's actually a provision in the EERA, the labor negotiation statute that governs school districts, that the Brown Act doesn't apply to certain things that go on in labor negotiations. So, like I said, she's much more of an expert on that than I am. But I think if something comes up, again, there's a hypothetical coming up that will illustrate. It's not about labor negotiation, it's just about when you would be in a special meeting. And in most cases, you can do almost anything in a special meeting. There are certain things you can't do in a special meeting you could do in a regular meeting. For example, you can't discuss salaries of higher level officials. You can't put ballot measures on, like the bonds and tax increases. All those things require regular meeting. But by and large, most things that you can do in a regular meeting, you can also do in a special meeting. The only difference is that it's on 24 hours notice. And if any press organs have asked for special notice of that meeting, then you have to give that. Almost none of the newspapers or radio stations ever ask for that, so it's really not an issue.
Excuse me.
Yes.
My understanding was if an ad hoc committee or just one board member even asked to be dealing with negotiations, that's supposed to be honored and they're put on with whoever is the negotiating team. Is that the case, or is that just personal preference whenever it suits?
That sounds more to me like local policy, and again, I'm not the expert on labor stuff, so, but I don't see that there would be a problem with that, but again, that's more like a matter of courtesy, you know. That if,
Right.
For example, a lot of times when you have trustee, do you have trustee areas here? Or you-
No,
large?
it's at large.
Good for you, because it gets to be a real problem when you have trustee areas and you can't find enough people. You guys have a terrible time filling one of their seats. For example, if a matter affects your trustee area specifically, then there's usually a courtesy that that board member is given some kind of preference as far as participating in those kinds of meetings and so forth. I know they do that at the board of supervisors, but not in the third district or the second district. Those are the people who are appointed to any committees that involve that area. So, but again, I think that's more just a matter of local policy or.
And if there's no policy written, then it's just a matter of the superintendent negating or allowing a member of the board to be on a committee like that.
I think so. Again, I don't know exactly what the protocol is for establishing labor negotiation teams.
Willits doesn't have a particularly normal protocol.
Well, and again, that's not a Brown Act issue, so you would have to worry about
so
it as a matter of Brown Act.
that was
law.
kind of a concern.
Yeah. Okay, emergency meetings. Hope you never have to have one of these. This is when you've had like a fire, a flood, earthquake, something like that.
Yeah.
And because of the disruption of public facilities, then you basically can meet on a street corner. This actually happened in Santa Rosa, I remember. They had terrible flooding back in the 2014 period. And of course, they had those terrible fires down there too. So in both cases, boards were just trying to get things you have to do then is you can simply hold the meeting, and then you have to notify the press as soon as possible afterwards that the meeting was held and what the action that was taken was and so forth. And finally, if you adjourn a regular meeting, and this happens sometimes, it gets late at night, do you meet at nighttime?
Yes,
Yeah.
You know, so it's getting like, 10, 11 o'clock, you're starting to fall asleep. And you decide, we really can't finish this tonight. You can continue that meeting. And if it's something that was one of those kind of rare number of things that can only be done at a regular meeting, you can continue that. And as long as you do it to a specific date and time, then that continues to be that same regular meeting for all purposes. It's useful also, like for example, if people can't get to the boardroom, you can have Michelle continue the meeting. The superintendent can call her and say, hey, we can't get enough board members in the room today. So then she can post something on the door that says this meeting today was continued, and you just put that where you would have put your Brown Act agenda. And then that tells the public that if they want to come to that meeting, now they're on notice what it is. Of course, you put it on your website and all the usual stuff too. But adjourned meetings can be useful if you run out of time and you need to do certain things on, before the next board meeting, for example.
Excuse me.
Oh, yeah.
I have a number of questions. On this window, doesn't that also apply to closed session meetings if you state at the end of the meeting that we'll continue this after the regular board meeting?
Well, that would be, essentially, if it happens on the same day, it's just the
Yeah.
same meeting. A
Oh,
lot of board-
okay, it still is.
I've
All
seen
right,
boards
I
use
thought
different
so.
things. Some of them hold closed session till the very end of the day. Others do it
Mhm.
right at the beginning, like they'll reserve an hour for closed session and then before the regular meeting starts. But as long as it's all on the same date, this doesn't really come into play. It's only if you need to continue it for some reason. And
On
then,
another day.
yeah, and then as long as you continue with the specific date and time and location, then you can do that and come back that day. And it's just as if the number it's all happened at once.
Okay, thanks. We've had those issues, is
Oh, yeah.
mostly the concern.
Okay, a majority of the board wishes to attend a school play. Is an agenda necessary? No, I think you all know this. Social or ceremonial occasions do not require an agenda. 3 or 4 years ago, when I did this here before, I told the superintendent they did not have to post an agenda because that was training. And we went through the first time, we didn't finish. And so the second time, Mark was so nervous, he went ahead and posted the agenda for the second one because I think not having that agenda out there when you've got a quorum of the board in the room just makes a lot of superintendents nervous. So, majority wishes to, here we are, a Brown Act workshop. Is an agenda necessary?
Yes.
No.
Okay.
That 54-952.2, subdivision C has 6 different exceptions to when a Brown Act agenda is necessary. Going to a gathering, even if it's a majority, for a training or something like that. For example, some bodies go like Sacramento or other cities like for a statewide conference. The majority of you can go to that as long as anybody else who wants to go to it is free to come in. Now, if there's a fee, the person who wants to attend has to pay that fee. But the workshop itself technically is one of the things that's exempt because it's in that list of things where you can, and the idea is you're not going to go there to discuss matters of the board, and you are prohibited from discussing anything within your jurisdiction while you're there. So today we can't discuss any specific issues that are before this body, but you certainly can ask general questions about the Brown Act. We're here for it. Most boards, again, will go ahead and post the agenda anyway.
So you can carpool?
Oh, yeah.
You don't talk about,
I remember back in the 90s, the 3 of the superintendents from Mendocino, supervisors from Mendocino County drove to Sacramento to give testimony together. Oh my God, they were calling the DA and saying, we've got this terrible Brown Act violation. But there's no proof they ever talked about anything to do with board business. Remember Charles Peterson was one of the supervisors at that time, the board. But he said, yeah, you talk about your dog, you talk about sports, you talk about your friends. You don't discuss this kind of stuff when you're out with other members. I think you get that beaten into you pretty quickly. After a meeting, on the other hand, after a meeting, board member number 1 emails number 2 and says they should agree to a settlement of a pending case. Board member number 2 agrees. Has there been a serial meeting? No. Unless this is a 3-member board. Because 2 would not be a quorum of the board. So, email a public record. emails, even among board members, confidential, and there's something called the deliberative process privilege. Very few board members who like to invoke this because it makes it look like you're having something to hide. So, but technically there are ways you could resist releasing that. It's one of those balancing tests that's in the Public Records Act. So. Same district, board member number 2 sees number 3 at the grocery store, and they talk about this problem. Number 3 agrees with number 2 and number 1 that a quick, reasonable settlement agreement makes the most sense. Has there been a serial meeting? Yes. Should board member number 3 send number 2 a confirming email?
No.
No. Yeah, this is, I guess you must just want to invite trouble. There's 2 analogies there. One is the rim of the bicycle wheel. You know, 1 talks to 2 and 2 talks to 3. You know, that kind of linkage among the board members themselves is a serial meeting. You could also have an individual who could go to board member number 1 and then come back and then say, hey, I just talked to board member number 1 when he goes to see number 2, and this is what I want you to do. And then he says, this is what board member number 1 said, so forth. So if that person is in the rim, the spoke of the wheel, rather, or the axle, the hub, yeah, then that person could be create a Brown Act violation. But if he's communicating messages back and forth, again, you cannot use a series of communications or any intermediaries to carry messages either. So in both of those situations, you would have a serial meeting. Before the next meeting, each board member separately emails the superintendent to express his or her views on an issue. Has there been a serial meeting? No. You can communicate with one person for anything. Again, the First Amendment says you have the right as a citizen of petition your government for redress of grievances. So anybody can go to each board member and talk about a pending issue and tell each board member what they think the board should do, as long as they're not carrying messages from one board member to another. Oh, I'll make available a copy of this with the answers in it if you'd like. The agenda calls for election of the governing board's officers. Members of the board agreed on the following procedure. Each member will cast an unsigned written ballot to be tallied by the superintendent, who will announce the results. Is this permissible?
Don't you have to do that in session?
Yeah, well, let's say that this is there, but you're using unsigned ballots. I actually saw this happen once. I was at a meeting for something completely different. A little school board, I don't know where it was, meeting in a gymnasium, and they did this exact thing. They said, okay, let's everybody write down our, who we're going to vote for, and then they put them like in a hat, and I raised my hand. I said, I'm not here for that, but you can't do that.
Maybe that would be a secret.
That's a secret ballot, exactly. If they each signed the ballots, that's different. Then that's okay. In fact, that's how the board of supervisors votes. So they've got the button thing there. They've got a green button, a red button, and a yellow button, and they all press those buttons under the dais there, and then the clerk of the board pushes a button and it appears up on the big board so everybody can see it. That's okay because they voted by name, even though it's kind of through this unusual method. But again, you can't take the secret ballot, preliminary or final. And of course, the board has to publicly report the results of any vote. If they're unsigned ballots, nobody's going to know who voted for whom. So this is how they used to do it at the old lodge meetings. You know, they have white balls and black balls. And anybody could put a black ball in the hopper there to say whether or not they were going to admit someone as a member. And if you got, that's where the term comes from. If you got a black ball, then you couldn't get into the group. And I even saw this on the Andy Griffith show many years ago. You had white, black. So, but that way, those are nice secret ballots. And that's, of course, not what you want to have with a government body. Board president is annoying the other board members. I'm sure this would never happen with this board, of course. But by his relentless criticism of district staff, the other board members want to remove him as an officer, but he claims they cannot penalize him for exercising his First Amendment rights. Who is right? Board or the board members? The board member or the rest of the board? Well, the answer here is the board member has the right to criticize within reason staff, and the majority has the right to choose its officers. That's an old federal court case there. Blair had a First Amendment right to criticize the superintendent. His fellow board members had the corresponding right to replace him with someone who represented the majority view. And then there's this case that came out, let's see, just in 2022 out of Houston. It was a community college down there. Mr. Wilson always was suing the board as a private citizen. Then he ran for the board, got on the board, and he continue suing his own board. And the board members revoked several of his appointments as a board member. They would not let him be on the, and they said any travel he was going to take had to be approved in advance. So of course, what do you think he did? He sued, yes. It went all the way to the United States Supreme Court. And they also censure it. In fact, I just saw something in the paper. I think this happened recently in Santa Rosa. One of the bodies down in Petaluma or school district or somebody. But yeah, if again, the court said that censure is a well-recognized. Again, you can't remove other board members. You can't restrict anything about what they can do. They all, each of you has an individual right to the same privileges as every other board member. But the majority can do certain things, such as strip people of titles. They can, again, require special requirements to get travel and all those things. So, then the court upheld the censure and the revocation of his appointments to various committees. So
Frank, what else can be done under a censure? I mean, what?
it's really just a way of putting a spotlight on somebody. Sometimes the political embarrassment is enough. These days, nobody seems to have any shame anymore. So I don't know how effective that is, but it is a way of saying we're not happy with your performance as a fellow board member. That's about it. It's just like, bad
So
blood.
is it done in a closed meeting?
Oh, no, this would have to be done in open. Anything involving a board member has to be done in open session. Because again, board members are not employees. So when we get to the closed session stuff about personnel matters, that does not involve, okay. That does not involve an employee. If it's a board member, it involves elected officials, and therefore everything involving elected officials, appointing a new board member, everything has to be done in open session. Can the vote to remove the, that's the very question. Can the vote to remove the officer be conducted in closed session? I just answered that. The answer was no. Okay. All right, sometimes you want that to listen. All right, adjournment of meetings. Any meeting may be adjourned and continued to a date certain. This is just picking up on something that was on an earlier slide. And again, there's a process to go through. Generally, an executive officer can do this. If, for example, nobody can get to the boardroom, I've seen that happen where literally because of terrible rain or fire, the board members can't even reach the boardroom. And again, if this gets adjourned, it constitutes a regular meeting for all purposes. So that's very useful, again, if you're trying to get something done on a regular meeting and it's late in the evening. Okay, locations of meetings. Excuse me. You have to conduct meetings within the boundaries of your body except when necessary to comply with the court order, to inspect property, to participate in meetings of multiple agencies, which is a fancy way of saying if two boards want to get together, by definition, both of you cannot meet in your own territory. So you have to pick one board's jurisdiction in order to meet. Meet with legislators and regulators. It's like our 3 board members who went to Sacramento that time. Meet with legal counsel, which is always puzzling me. I always go to the client. They never come to me. And then finally, due to a real emergency, which of course is a huge exception for emergency meetings where you don't have to comply with any of the normal Brown Act requirements. Okay. Teleconferencing. Again, this is our big new topic here now. Teleconferencing originally came in back in the mid-1980s. And the idea was that if you're out of town on business or if you are ill, you can still participate. In the old days, it was literally a phone call. People would be on this little speaker phone. Now, of course, everybody does Zoom. So you're going to use what are called traditional teleconference rooms. This is the way the legislature originally passed this. And this is not affected in the slightest by SB 707. They left this untouched. So which is good to know because everybody's familiar with these rules for the most part. So you have to tell where the other person is located, the fishing cabin in Alaska, the hotel in New York City, whatever it is. The agenda has to be posted at that remote location. I'm not sure too many bears are going to come by to look at a agenda posted on the wall in that cabin in Alaska, but for good faith, it's a good idea to comply with that requirement. And again, if it's a hotel or someplace like that, you have to post at a public location, just as if you were in your home jurisdiction. Each teleconference location has to be accessible to the public. It also has to be handicap accessible, just like hotel room, for example, if it's not handicap accessible. The public may attend the meeting at the remote location, which does happen sometimes. MTA, the bus company here, they routinely hold 2 meetings each time that they meet in 2 different locations to kind of emphasize the idea that they're transportation. So they'll meet in Fort Bragg and Ukiah, then they'll meet in Point Arena and Willits. So they like to move their meetings around, and again, they set it up so that there's always a remote link for everybody who wants to show up at one and the other location if they want to attend in person. Any vote must be done by roll call, which doesn't sound like it's much, but I'll tell you, if you had to do roll call votes repeatedly, it gets pretty tiring. So you can't even like say, you know, the agenda's approved, all in favor, no, you gotta call the roll, so. The majority must be located within the territory of the district. This theoretically means that if you had 5 handicapped accessible locations and you complied with all these other requirements, each of you could be in a separate location, as long as you're all within the territory of, or a majority of you are within the territory of the school district. We had a big argument about this in my office because somebody said, well, that's not a congregation in one place. But there's no restriction on that, as there is with the other 2 kinds that the legislature has now created. So that's okay to have everybody in different locations as long as everybody follows all the other rules about agenda posting and being accessible and so forth. The traditional rules remain unchanged, so that's always good. All right, and thankfully they shook out, I think they took that 54-953 and crammed it with so much stuff it was longer than the rest of the Brown Act when they started all this teleconferencing thing on paper. Now they've pulled out most of those provisions and created new statutes for most of them. Okay, virtual meetings. So this was the one that was originally under AB 361, AB 557. That's the middle column on that teleconferencing chart that I hopefully you got. There are 3 columns on there. The traditional teleconferencing tracks down on the left-hand side. This is in the middle. I now changed that because AB 361 and 557 were supplanted by SB 707. Created all these new code sections, and they took this statute, which had been set. Well, originally that one was already, SB 557 made that a permanent part of the Brown Act. So this was the one that was used during the pandemic. You can use teleconferencing only if you hold a meeting during a proclaimed state of emergency. I don't know how many of you were on the board and got to do this when the pandemic was on. You hold the meeting during a proclaimed state of emergency for the purpose of, first you have to meet to determine is there a proclaimed state of emergency. That's kind of a formality. So then once you do that, then the board members can meet, again, anywhere. And there's no requirement you post agendas or note your location. You just have to be on the line when the meeting gets started. So the idea here is that because of safety risks, typically a communicable disease that's afoot in the community, then you do not all have to go anywhere physical, but you can do it all by Zoom. And again, I'm sure those of you who were on the board that I remember those, right? I mean, again, this is the way I was always expecting things would sort of move, which is that you go to virtual meetings for everything, but they're really holding tight to this thing about physical meetings, I guess. It's a little too far for them yet. Okay, so these have now been confirmed by SB 707. So this is now a permanent part of the Act, and SB 707 recognizes it. Okay. So this was the old rule under AB 2449557. This is now, again, extended. So this is now good through January 2030. These were the 2 new rules they created. What they did, though, was they got rid of some of the old designations and they combined them together. So we used to have 2 sets of special circumstances for people to participate remotely as individuals. If you use those provisions, the just cause and what used to be called emergency circumstances, at least a quorum has to be in a singular physical location. So at least 3 of you have to be in the same room, basically. You may participate without standard teleconferencing requirements. Again, emergency circumstances has now been folded into just cause. There are restrictions on how frequently. The chart actually is more up to date than this now, but basically, you get 2 uses. You only meet once a month, right?
Yes.
Yeah. You only meet once a month, and you get to use it 2 times per calendar year. So you got to kind of save that chip for when you really need it. Again, people This is the new law. It was passed in October, it took effect. When I originally wrote this, it hadn't quite gotten to January yet. There are some significant changes to the Brown. They created whole new chunks of statutes to deal with teleconferencing in particular, but also some other. There's a chart in your materials there. Yeah, there's a copy of the materials. No, you need one. Oh, this? Yeah. No, the whole. Oh. Page. Right at the very end. Yeah, on pages 47 and 48 of our material, there's a more comprehensive list of the changes that SB 707 made. This was the most significant update to the Brown Act in 30 years. Last time they really made this much of a change was in 1994. So it's been a big watershed. And everybody is still kind of learning these rules. I'm still learning them, so it's everybody's a little shaky on the technical stuff here, but so telecasting of meetings. They've now added special requirements. They want to basically emphasize non-discrimination. They require boards, some boards, to do affirmative action outreach, get more people to participate. They have quorum requirements for remote participation, and they kind of beefed up a little bit the handling of disruptive attendees, which has been a problem more and more these days. School boards have been particular lightning rods for controversial issues. They removed the sunset language for the what used to be the just cause emergency circumstances. It's now just called just cause, and those are in place now until the end of 2029. I don't know why they didn't just leave them in place. Quite frankly, they've been working very well for the last 3 or 4 years since they put this in the Brown Act. And again, they took effect January 1st. There are a few that don't apply to these kinds of boards. There's this really weird whole other chunk of stuff, which thankfully you don't have to worry about. For certain kinds of legislative bodies that have like more than 30,000 constituents, they've imposed all kinds of additional requirements, like you have to have Zoom meetings for people who want to attend that way. You have to broadcast the meeting. Again, larger cities and larger school districts may have to deal with that. Fortunately, you will not. So, okay, so yeah, the chart I think gives you more information about that, both the one on 47 and 48 and the teleconferencing chart, standalone one. Okay, let's talk about agendas. Let's have a timely and meaningful agenda. That's the language out of the Brown Act. You have the right to review the agenda in advance of meetings. It has to be posted 3 days in advance for a regular meeting. Attend all meetings in person and observe all deliberations except for closed sessions. You have the right to comment to the board on agenda items and issues within the board's subject matter jurisdiction. You have the right to record the audio or video of a meeting or both. And you have the right to obtain copies of all open sessions. So anything distributed in an open session, you have the right to obtain copies of if you're a citizen. There was a case a few years ago that created a lot of confusion. The legislature tried to correct that. It's not quite comparison with the Brown Act. The agenda has to have a brief description of the items to be discussed or acted upon. And again, there is a requirement you have to specify whether it's to be discussed only or whether you're going to vote. Because that way, if it's only discussion, maybe I don't need to be there because it's not that big a deal yet. They're not going to vote on it. On the other hand, if it's a vote, yeah, I better be there if I'm interested in this issue because now as a citizen, I want to have my say before the board acts on that. Public writings distributed to board members less than 72 hours before a meeting must be made available at the time of distribution. This was that case I was mentioning. They distributed the materials to the board members on a Friday and the meeting was on Monday. Well, if you remember, the public in the office is locked. You can't get a copy of the material. And the public entities argued that, well, putting it online should be good. That's what you do with everything else. And the court, for some reason, said, no, that's not good enough. You have to have physical copies. So now you have to like leave a stack outside with a rock on it, I guess. That's the only way you can deliver them. So hopefully, you get the stuff to the board member. Either you need to distribute it at the meeting, in which case nothing has to be done in advance, or you have to make physical copies available as well as you have to, at the time you distribute it to the board members and post it online. Again, if you're closed, physical copies must be made available the next business day. Internet posting is not adequate. The legislative body is prohibited from taking action on any item not Okay, here's another.
What are the exceptions?
Well, there's a process you can go through, and it's in here a little later, but it's basically what's called an off-agenda item. I don't know if you've ever participated in one of those. Because occasionally something will come up on short notice and you need to take action right away. That's basically when you do that. It's kind of a little, sets you kind of back-footed, I think, for a lot of people, the idea that you can take action on something that was not on the agenda. But there is this whole process you have to go through to get there. So I'll walk you through it when we get to that part of the presentation here. 2 days before the regular meeting, the superintendent emails the board a revised report for an open session item at the meeting. A member of the public hears about the report from the board member and asks for a copy. He is told to wait until the meeting. This is the big no-no here. Is that legal? Of course, the answer is no. Documents have to be provided. If they are provided to a majority of the board, just give it to the chair and maybe one other board member, that's okay, because then it hasn't been distributed to a quorum. But if a quorum of the board gets a document, then the public has the right to get access to that immediately. And again, physical copies have to be made available the next business day if you have them.
Excuse me.
Yes?
And is that okay that one or two people of the board receive a copy and the rest do not?
That's kind of a internal thing again, I
Yeah.
think. I mean, typically the chair is the one who would be the one to get that. But if the document exists, I think most people would say, well, it really should just go to the whole board. And then, of course, in that case, that triggers the access requirement. So it's kind of, I think, a call for the superintendent, you know, that if you want to make this available now and then have to deal with making it available to the public, or do you want to just hold it for the meeting, in which case the board members are frantically trying to read through something.
Yeah.
So there's kind of a downside to both
It's
situations.
just that you said earlier that the president or whatever officers have all the same equal standing and rights as the members.
Well, they do. The board president typically does have certain privileges that other board members do, like they call,
Well, they have a lot
call
of
special
say.
meetings. And,
Exactly.
yeah. So the idea is, I guess, that's the person you go to first. And sometimes that person has a good sense of, like, we'll just work with the whole board. And so, good.
Is it a given that they would pass out the information they receive, or that's more
Well,
a personal decision?
Yeah, if the chair gets it and then passes it to the board members, that triggers the same provision. You then have to give it to everybody in the public.
Okay.
Because again, this is just a report, it's not some kind of secret thing. Again, this is for an open session item too, which is important to keep in mind. Okay, I mean, that .5 section that they added after that court case. All right, superintendent decides to announce her retirement. May she do so at tonight's meeting, even though it is not on the agenda?
I would say yes.
You say yes? Yeah, the answer is yes. No action or discussion shall be undertaken if something is not on the agenda, but a brief announcement or a brief report is permissible. And in addition, many agendas actually have dedicated items that are on every agenda that say matters from the board, matters from staff, to recognize that board members may want to report back in the open session in front of everybody else what they've been doing. So, you know, I visited this school, or I went on this trip, and I met this person dealing with education, or what have you. And, or in some cases, staff members, like the superintendent, want to bring up things to the board, say, hey, there's this issue coming up here, you know, we need to start thinking about issue such and such, and I just want to, you know, make you aware of that. Again, you can't have any discussion about the item at that time, but it's just to put board members on notice of certain things that they might not otherwise.
So matters from board members would be the same thing as board comments, is that correct?
Yeah, I think that's, there are different ways I've seen it on agendas, that would be another way to look at it. When I worked for the county, I was most familiar with the planning commission, and they would usually, again, come in and talk about, like, you know, there's this new trail that's been opened up over on the coast, and I want everybody to go visit, it's a wonderful place, and, you know, stuff like that. It's just kind of their experiences over the time since the last meeting. But, and again, it's as long as it's just a one-way information flow from the person to the public, that's okay. At the beginning of a regular meeting, the board president announces she wants to reorder the agenda to move the last item to the beginning to accommodate a board member who has to leave early. Is this permissible? Yes. This is common in legislative matters. Changes to the agenda are within the discretion typically of the chair. Sometimes there's actually a whole process under Robert's rules to appeal a decision of the chair to the full board, and sometimes boards get kind of nasty with each other. People are appealing what the board ruled on certain things and so forth. If you have a timed item, which is not common, I think, with school boards, but when I worked in the county, that was common if there was like a really controversial land use issue or something. You can't take there's an item that I want to be there for, and it's the 7th item on the agenda, the board may decide to move that to number 1. So therefore, I better be there when the meeting starts if I'm interested in it, even though I probably will have to sit there until they get to it in order. Because I've seen that happen. People will show up and, oh, well, we took that item up half an hour ago. So, there's nothing wrong with that as long as, it's done through a normal process by the board. Because again, the timing of the agenda, or the order of the agenda, that's really very much within the board's discretion. 2 days before a regular board meeting, this is the off-agenda situation. The superintendent receives a demand letter from a contractor threatening to sue the district for breach of contract. The superintendent wishes to update the board. Can the board consider this item at its regular meeting, even though it is not on the agenda? Well, normally they could not, but they can, because there's this process here under that point 2 section there. If it arises within if an issue arises within 72 hours of the agenda having been posted, and there's a need to take immediate action, we've got a threat of litigation here. So the board may want to act on this, get legal counsel involved right away, contact the other party, give direction to the superintendent about what to tell the other party, and so forth. In that case, you can add this to the regular agenda at the meeting, as long as you meet those 2 criteria. If it arose within 72 hours of posting, and there's a need to take immediate action, you can't wait for the next meeting.
So since this involves litigation, it would be dealt with in a closed session, right?
And you could also, yes, you could put on a closed session to discuss the item. And normally the way you do that is move, I move to add a closed session item to discuss the threat of litigation that we received, usually having that letter or whatever it is, with the board packet that's, we can do that. And then just say, I move that, and then somebody says second, and you have to have a supermajority vote, 2/3. For this body, that would be 4 out of 5, or only 3 of you are present, unanimous vote to add this to the agenda. And if you do that, then it just gets added to the agenda as another item. And the board can take action on it somewhere during the meeting, since it's been there the whole time. Yes, sir.
Is there actually a specified amount of time that the agenda has to be posted prior to the actual meeting?
Yes, 72 hours.
72 hours.
Yeah, in fact, I've seen people, we posted it at this time, so we can't start the meeting for another 10 minutes because that wouldn't be 72 hours. And, you have to be very, the person, I guess like Michelle here, I assume you're the one who's responsible for posting the agenda, you have to be very careful about the timing. If you blow that deadline, then the board meeting has to be delayed until the 72 hours has elapsed. So, even if it's been online the whole time. Okay, or you can add a special meeting. If this is something that could have been discussed at a special meeting and there's more than 24 hours rather, then you can have a special meeting on 24 hours notice, and you just add that basically to the agenda, and it'll say special meeting. Notice the special meeting looks just like the regular meeting agenda, except it says special meeting, and you can post that up to 24 hours before the meeting. That's sometimes easier than having to go through this rigmarole here with the 2/3 item on the agenda at the last minute. And it does put the public on notice too. So, all right, off agenda items. This is the process again. If you have an emergency, a majority vote is sufficient to do that. Of course, I doubt that that's, in most cases, that's normally the same circumstances, fire, flood, earthquake, and so forth. So that's a very rare one. More commonly, you use the 2/3 vote. You take that vote before the next meeting, or at the meeting, and then you have to make those 2 findings. If the board members feel that they can make those 2 findings in good faith, and again, I don't think the court is going to disturb that. If the facts are well stated in the record, then you just add it to the agenda. So again, you get that. And then once it's added to the agenda, it's a regular majority item. If it's something that's not in closed session, then when you vote on the item itself, you still have a 3-2 vote that would be adequate. Okay, the item open session agenda contains the following items of business: consideration of contract with Smith Consulting, approval of committee recommendations. Is either description sufficiently adequate for the public to understand the items?
I would say the first one.
Yeah, I think the first one is probably better than number 2. I think you'd have to know a bit more about what kind of consulting Smith is doing. Approval of committee recommendations is also kind of a red flag. This is based on this language in the Brown Act that The agenda has to include a brief general description of each item of business, which generally need not exceed 20 words. Yeah, you have to be careful not to use a word like approval, because that's not something that the board should be told in advance that they should do. It should be, say, consideration or discussion and possible action about, something like that. Approval is not the right word, because that suggests that you can't, or you shouldn't say no, and the board can always say no, so. Again, without predetermining the outcome. All right, closed sessions. These are the generally permissible closed session topics. I did put in the packet, by the way, there's, I think it's listed on in the table of contents there.
Sure.
On page 49, I put in something, government code 54954.9.5. That's my little roadmap for these things here. Okay, personnel matters, conference with legal counsel, labor negotiations, real property negotiations, and student issues are the most common. I mean, there are many, many other closed session items in the Brown Act, but these are the ones. Again, some of them have to do with hospital districts and so forth. So these are the ones you're most likely to come upon in your work. That 54954.5 code section, which I included, I use that as a checklist, because what's nice is when somebody says, I need to discuss this thing, can I do it in closed session? First thing I do is open up the code to that page, and then I start reading through the exceptions there to make sure that I've missed something. And normally, there may be something, other cases there may not. What's nice about that code section is two things. One is because it does give you, it's not a comprehensive list, unfortunately. But the second thing is, if you describe the item, and you'll see the examples up here, in the same language that's in 54954.5, which is not mandatory, but if you use that language, then you are not susceptible to challenge later because it was an inadequate description. What was great about this is the legislature actually put canned language into the code itself that says this is what you have to say on the agenda for a closed session item on topic X, and that's all you have to do. And it's really nice to have that little recipe to follow there, because then you don't have to worry that you didn't say enough. Because before this section was added, everybody was kind of at sea, like, well, is this enough description? Because you don't want to give too much away in a closed session description either.
So Frank, there's, like, to me, there's lots of things that could be student issues.
Right, well, it's usually the two things that you would have to deal with, expulsions and suspensions.
Okay.
So beyond that, I think if it's anything that's more generic than that, that's probably not a closed session,
Okay.
because that's more board policy
Right.
topic then. Must the board president allow public comment at a special meeting prior to, when this says public comment, well, you'll see the answer here, so what would you all say? The answer is yes, but it's limited to the agenda items. Unlike the regular agenda where you can come in and talk about anything under the sun that's also under the board's jurisdiction, in a special meeting, the only thing that the public can comment on is the items on the special meeting agenda. That's the other big distinction between a special meeting and a regular meeting. There's no general public comment. When I worked in the county, people, because this was local government, they thought that this was their chance to come in and talk about anything. A guy showed up one time, he wanted to talk to the board of supervisors about, they were using plutonium for one of the ships being sent to Saturn. And he was worried that it was going to blow up and they were going to rain plutonium all over the country. And I don't think they had a whole lot to do with that, but he thought this was his chance to get up there and give his 3 minutes. Must the board president make any announcement prior to the beginning of the closed session, and if so, what? Yeah. Prior to the closed session, the board shall disclose in an open meeting the item or items to be discussed in closed session, which generally just involves the chair reading what's on the agenda that says, okay, we're going to go in on item 3, discussion with legal counsel, and cites what section, that's it, whatever's on the agenda. So that's a very simple way to make that announcement, but it does tell the board, the public, if they're sitting there, that that's what you're going to do. And in some cases, the board will do this early, so almost nobody from the public or anybody from the public will be there. When I worked for Mendocino County, when I started out, they used to do closed session in the middle of the meeting. So they'd be going along for a while, and then they'd have this break to go into closed session, then they'd come back, and people would sit out there. So they finally decided to move it all to the early part of the agenda, and that sort of took care of a lot of that. Wait. Okay, personnel issues. This is the first one. This one is split into 4 parts. Public employee appointment, you specify the title of the position only. That's all you have to put on there. public employment. Now this one, we kind of felt like, if you read the code, it actually says specify description of position to be filled. And I've always said that was a misprint. I don't think that's what was really intended by this. There's no reason to have two of these if they're both going to relate to the same thing. So we've interpreted that to mean you can use that for employee-related matters. Somebody's going to go on medical leave, you don't want to disclose like that they're ill with this or that disease. So that's one way to use that. But I think that's usually for things that aren't directly related to hiring somebody. So there may be other employee matters that the superintendent justifiably discuss with the board. Public employee performance evaluation, that's usually only for employees like the superintendent who you actually appoint. For lower level employees, that normally does not go into closed session unless it's just that the board has to ratify the hiring of someone. And then again, you just have to put the position, the title that's being reviewed. So it'll say public employee performance evaluation, superintendent. And then finally, public employee discipline, dismissal, or release. This is the sad one. No additional information is required. You do not have to list the name of the position even, so that's good, because that way it doesn't put anybody theoretically on notice who the person is. This could include the potential reduction of compensation. So again, discipline, dismissal, or release. I guess dismissal and release are different, because dismissal means you fire the person, release means, for example, you're just not going to continue the contract. So, okay. The board is meeting in closed session to evaluate the superintendent and consider giving her pay raise. Will the superintendent attend the closed session? Here's a very lawyerly answer. Yes and no. An evaluation is conducted under that code section. The superintendent can attend the evaluation at the board's request. The employee being evaluated does not have an absolute right to be present during closed session. And you cannot discuss salary except as discipline. So you can do, or I should say, you can discuss it, but there's a whole other process you have to go through to raise the salary. It has to be done at a regular meeting. It has to be done, the board discusses it in closed session, but they cannot. Well, actually, I'm talking about two different things here. One is a contract renewal. The other one would be evaluation. During an evaluation, you're not supposed to discuss salary. During a discussion about whether to extend the contract, that would be something you necessarily discuss, but then you have to vote on it in open session.
Okay, so hypothetically, we have a superintendent who is given the list by the school board. So the school board would have to do that in open session?
Oh, yeah. And anytime you get into compensation, it has to be put on separately. It's not an evaluation anymore. It's, like I said, you can't discuss salaries for just a regular evaluation. So it has to be put on that way, consideration of possible bonus for superintendent, something like that. And then you can go into closed session, discuss it, and then there's this whole pattern you have to do to get them out of closed session. And then we have to announce that we've made a decision, and then the board votes on it in open session. Pay rates for unrepresented employees are discussed in closed session, and then the superintendent, again, you should not be present if the employee being evaluated in that sense. In closed session, the board gives instructions to their negotiator, who then meets with the superintendent outside of the closed session and reports back to the board. I think that's what you were saying earlier, Justin. Sometimes the board president is the one tasked with negotiations and so forth. Oh, okay. I'm not misunderstood that. I know, like, for example, when I worked for the county, we had 3 employees who typically, well, they weren't even employees. One of them was the county auditor, who's an elected official, and he was appointed to be one of the negotiators, and then they had somebody, I guess, the head of the personnel department, and then they had somebody else also did all the negotiations. So, but again, there was like a little team. They would negotiate and then take this back to the board. Final action on pay changes has to be made in open session. And again, this is like actually like, not dialogue so much, but there are certain things that have to be stated in open session in order to make the change. Okay, may the board discuss the workload of district administrative staff and the need for an assistant superintendent in closed session under the personnel exception.
Closed session.
Yeah. Abstract discussion of policies and operations, including whether to hire a particular, not particular, but like create a new position. That's all open session discussion. That's budgetary stuff. You can discuss only the decision whether to hire a specific individual in closed session. Not discuss we need more personnel for this function. Several board members are unhappy with the district's architect who insists on preparing overly robust designs. Can the board discuss its evaluation of the architect's performance in closed session? The answer here is no. The board may evaluate district contract employees, and of course other employees that they hire, but not independent contractors nor other elected officials. So all of that is limited to the open session. The architect is furious when he hears that someone has criticized his work. He tells the board president, "I'll see you in court." Now can the board discuss architect's performance in closed session? Yes. Because now you've got a threat of litigation. Anticipated litigation conference with legal counsel is a permissible closed session topic as long as there is a bona fide threat of litigation and the threat is documented in the record. So, in fact, there are situations where a statement made at a board meeting is the basis to go into closed session immediately as long as you document that in the record. I wonder, we're almost an hour and a half in. Could we take a quick break here?
Sure.
Okay. I was going to try to take a break between the two topics. We're getting close to the end. 5, 10, whatever works for the board. Oh, yeah, okay. That's what it'll be.
The meeting is adjourned for a break, 10-minute break, and the time is now 10:23. The special meeting in the Warren White School District, board meeting is reconvened at 10:36.
Special meeting. All right. Litigation. Conference with legal counsel. Existing litigation is one basis to go into closed session. You have to specify the name of the case if it's been filed. This includes administrative matters, things like what's involved with an OSHA case, things like that, when there is a proceeding, but it's not a court case, but it is still a legal proceeding. In some cases, I don't think this is very common, not list the case name would jeopardize service. The service process might be an issue because you don't want somebody sometimes to know that you're going to sue them. But generally speaking, you put that information on there, and then the board can discuss. This is also true for claims for damages that you can certainly claim. It doesn't happen that often. I was kind of surprised to find this out. It's like a daily occurrence when I work with the guy. Conference with legal counsel, anticipated litigation. This is where there's no litigation pending, but there's significant exposure to litigation. That's the language that they use. Specify the number of cases. That's all you have to put down. In some cases, the agency may be required to provide additional information on the agenda or an oral statement before the closed session to disclose what's going on that you have to discuss. I think districts have a lot of discretion about whether or not to do that, because in most cases, you generally don't want this information. That's why you're discussing out there, that the information to be out there, because that's why you're having a closed session. So, in addition, if the board is thinking about suing someone, you can also put that on. You can list a number of cases. In connection with an upcoming meeting, legal counsel for the board. Oh, I should have said something else here too. The most important thing to remember here is you have to have the attorney in the room or on the phone. I've talked to superintendents sometimes. They said they wanted they're thinking about such and such, and I said, well, you would have a closed session on this. They said, oh, we already discussed that in closed session. You don't have, again, it's conference with legal counsel. It's not conference to discuss litigation, so it's important to keep that in mind. All right, in connection with an upcoming meeting, legal counsel emails a memorandum to all members of the board outlining litigation risks on a potential claim. Must this memorandum be included in the publicly available materials? I think you all kind of have a sense of this, and the answer is no. The whole idea of attorney-client communications is it's confidential, and that there are situations where public entities may need to seek legal counsel in confidence. It's protected by the attorney-client privilege. There was actually this case about 30 years ago where this fellow insisted that he had the right to see the memo from the legal counsel to the board. But all the way to the California Supreme Court, they said no. So, yeah, closed session materials are, this is where I have to do the presentation. Materials are confidential, but again, the attorney has to be in the room during the closed session. This could be a legal closed session. Not too plain on horn there or anything, but that's just the nature of the beast.
In the room or by phone?
Oh, by phone is fine.
By
Yeah, no,
phone.
some of these little districts up in Humboldt County, I mean, you would need like a 3-day head start. They're really remote in some places. I mean, I visited Horicon School District recently, and that's way out on the coast.
That's near Point Arena, right?
What's that?
Near Point Arena.
It's near Point Arena, yeah, that's one of the districts, that's one of the feeder districts to the Point Arena district. And I'll tell you, that is a, I mean, boy, talk about a Dramamine drive. I got lost, actually. I missed the turnoff, and I ended up at the coast, and I had to turn around and go back. It's really way out. It's much better to do that by Zoom if you can. Conference with labor negotiations, agency designates the representatives. These are the people who will be negotiating and then attending the closed session. The idea is that you send your negotiators out, they confer with the other party, and then you come back and confer with the board. Which organization you're dealing with, you specify basically the name of the union, CSEA. You have unions here, I see, right? Yeah. And then also, in some cases, you have unrepresented employees. This is where you could do the pay increase, for example, for the superintendent. This would be treated as labor negotiations. So you specify the title of the unrepresented employee, who's the subject, and that's all you have to put on the agenda. So that's essentially how you get the pay question separate from the evaluation. Okay, real property negotiations. If you want to buy property, and that's specific to this, you have to specify the street address or no street address, a parcel number, something to identify, some unique identifier for the real property. The agency negotiator, you identify who the people are that will get you the negotiators for the district, because the board members normally do not get involved in that. The negotiating parties, that's who are you negotiating with? In other words, who's the other person that might be the seller? And then finally, what is under negotiation? That just is price, terms, or both. Usually you put both, just because even if you don't have to discuss both of them, it may come up, so why not cover yourself in that situation? Okay, the district intends to evaluate its options relating to the sale or lease of surplus property. The superintendent discussed the options with the board in closed session, and if so, what is the agenda listed? Well, I can tell you right now, that's not the case is no. It's not advancing.
Do you have a reboot thing? That window to open up?
Oh, that
There
was
it
just,
goes.
oh. The magic touch. Okay, it depends. Again, general policy discussions and explanations of process do not fall within closed session. Generally, real property issues that can go into closed session are only the decision whether or not to discuss purchasing a new piece of property. Something like disposing of surplus property because there's that whole 7-Eleven process out there, that's kind of an open session item because the board will then appoint the committee and then they're the ones that will go out and actually do the evaluation. Again, the amount of consideration, the form, manner, and timing of the consideration, and items that are essential to arriving at the authorized price. And again, purchase, sale, exchange, or lease. I think price and terms is a lot simpler because that's basically what you're going to be discussing. But again, it has to relate to a specific parcel. You can't discuss generally like should we buy more land or should we, do we need a new high school? Those kinds of things are open session discussions only. Okay, student issues. Now this one is not in the Brown Act, which is kind of a problem because they don't have that nice canned language here. So we've come up with our own here. Consideration of suspension or other disciplinary action other than expulsion of a student. And then you list those two code sections. Hearing to discuss, consider deliberations regarding the expulsion of a student. This hearing will be held in closed session unless a timely request for an open hearing is made. Again, the students' parents can ask for open session, and you have to abide by that. If you give them 24 hours notice and they say they wanted an open session, in most cases they do not. And then the case number, is, again, that's something that's an internal number that you assign to the matter. It does not have the student's name. And again, do not use the student's name, create some kind of unique number to identify the student so everybody knows which case you're talking about. Sometimes you'll have more than one. Now, if you conduct an expulsion hearing in closed session, the final action has to be taken in open session. And again, all you would say is final action on expulsion of pupil, case number such and such. You do not use the student's name in this situation. You just identify that you have considered this in closed session, and the board, by this vote, reached a decision of 4-1. It was the trustees who voted with each side, and that's the conclusion of the matter.
Does the suspension always have to be before the board?
You know,
This is the way
It doesn't happen.
Yeah,
The way it works for expulsion is just that, of course, you do have to suspend the kids for some amount of days. And then if it's been brought to the board for expulsion, so that's the after. So suspension before, yeah.
Right, but does the suspension need to come before the board the way the expulsion
no.
does?
Yeah, that's what I was thinking.
Oh, okay.
No, suspension is by the school principal based on the matter. And then expulsion, if it goes to expulsion to expelling the kid from outside the school, then it's what.
Yeah, this board can do that. And of course, those are appealable to the County Board of Education
Right.
too, so. Okay. Closed session and reportable action. Certain final action taken in closed session must be reported in open session. So again, like that last one there, when you take a vote, you have to report that out at the end of the closed session. Reporting a final settlement agreement and final personnel action. Those are both reported out at the end of the closed session. Excuse me, preliminary action is not. So for example, the decision to move in a certain direction is not be reportable, only the decision to take final action. You do not list the employee's name in connection with discipline, and that's Government Code 54.957.1. Okay, what closed session listing should be used when the board is asked to approve employee discipline? Again, we saw this before. Discipline, dismissal, and release. I had a school district up in Humboldt County a couple of years ago where they fired a principal, and it was only on for discipline, dismissal, release, no name of the party or anything. And this one attorney would not let it go. He was like a pit bull hanging on to this thing. He kept saying, no, you have to have more information on the agenda, because this guy was very popular with the parents. And we kept saying, read the code. It's all we have to put on the agenda ever in a closed session for employee discipline. And I mean, he was threatening litigation and so forth, sending these like 50-page letters, attachments from the internet. It was crazy. But yeah, that's all you ever have to put on for an employee discipline matter. Is a 5-0 vote in closed session to pursue a disciplinary hearing reportable? This is what I said a minute ago. The answer is no. A decision to pursue a disciplinary hearing itself is not reportable, only final action. So if you decide to fire the person and that decision the board made, that's reportable, but decision to pursue discipline is not reportable. Is the employee entitled to notice of the fact that the board will be discussing their conduct in closed session? Well, in this case, it's not if the discussion is a general performance evaluation. But again, that'll be on the agenda so the employee will know. But the closed session agenda should not list the employee's title. If it's a that's not correct, actually. I mean, you would always include the employee's title if you're going to do an evaluation. I think what that means is if it's, again, discipline, you should not include the employee's title because that could be a potential red flag. It might be only one person that holds a particular title. Can the employee demand to be heard by the board in closed session? Well, here's another one of these. Specific complaints or charges, yes. Otherwise, no. Again, if it's a general performance evaluation, then the employee does not have the right to be present for that, as I said in an earlier slide. But if there are specific complaints or charges that some parent has come forward with some complaint about the employee, then you have to give the employee 24 hours notice, and if you act on that, say to discipline them, classified employees, I think, are more susceptible here because it's very, very hard to move forward with a disciplinary matter against a certificated employee. But the employee can insist that it be held in open session if it does involve specific complaints or charges. I did it again.
Look at you have to escape.
Oh, escape, okay.
Try.
Try that now. Yep, there we go. 54,957, again, if there's a specific complaints or charges, the employee has the right to have that heard in open session. Deliberations, though, even in that situation, are still held in closed session, and then you report out with the board's decision. Okay, in closed session, after learning of new information, the board votes 3-2 to rescind that earlier decision to pursue disciplinary action. Is this reportable in open session?
Yes.
This is an interesting one. No, because this is not final action either. My colleague, Bob Henry, who's like this very well-respected education attorney statewide, actually solicited one of his colleagues with or one of his acquaintances at the legislature to seek the Attorney General opinion there. And the Attorney General confirmed that a vote to maintain the status quo is not final action, because nothing has changed, except internal decisions by the board, but nothing that would change the employee status. So that's a vote to maintain the status quo. All right, finally, I'll wake you up. Again, invalidation, people can sue to overturn a decision by the board. They do have to give you a notice in 20 days to change something you did during a meeting where they say there was a improper agenda or there was some other mistake that the board made in noticing the item. And that they have to make a cure and correct demand before they can go to court. So that's helpful because that way you don't get sued immediately when somebody gets it in their head that there was a violation. Civil actions can also, again, as I said earlier, cost you money in terms of attorney's fees. And in some cases, if there's an allegation that the board members violated their closed session, that they discussed things they shouldn't have, they can actually have the district attorney can sue to have closed session meetings tape recorded. I guess now it would be like, audio recorded with various things. And I always thought that was kind of a really silly thing, because in the judge's review, which you do in closed session, I mean, they're listening to this thing, and you know that you're being recorded, right? And so the board members are sitting around saying, well, here we are once again, giving up our precious personal time to do the public's business, and they go on for like an hour, like, I mean, how much of that could you stand to listen to? And then finally, again, everybody hears about this, nobody really seems to understand this. It is a misdemeanor for the board to take action, meaning a vote, with the intent to deprive the public of information it would otherwise be entitled to. I remember I had a phone call from some fire district or somebody were thinking about buying a new piece of equipment, and I asked him, well, do you want to discuss this? And he said, oh, we already discussed that over lunch the other day. So I gave him his Miranda warning, and because actually did sort of reach a consensus about this. And it's all attorney-client privilege, so. But yeah, the idea is that basically they say, yes, we know this is wrong, and we're going to go ahead and do it anyway. That would be the criminal misdemeanor. And as far as I know, there has never been a prosecution for a criminal violation of the Brown Act. So, but it's out there, and again, I think it just kind of keeps people, thinking about that. Okay, that is the conclusion of our Brown Act material. So we'll move on to conflicts of interest. A board member shall not have a financial interest in any contract made by the board. This is Government Code 1090. This is kind of the granddaddy of the conflict of interest or ethical laws. A board member shall not vote on a matter that involves a financial conflict. If it doesn't involve a contract, but nevertheless it involves property that you own or a business that you own or something like that, then you should not vote on that. That's the Political Reform Act. That's Government Code 8700. You shall not vote on a matter that involves common law conflict, which means personal bias. Yeah.
Okay, I'm not sure what they mean by personal bias.
Well,
I think to me it kind of sounds like you have a pre-existing opinion of the matter, which seems not anything.
well, it means, for example, I didn't put it in here because we have a much longer ethical presentation than 2-hour one, but we have an example that somebody gets money, somebody hands them money within the limit for gifts in, say, the end of 2025, and then in 2026, they get more money from this person, which is a new year, and then 3 months later, that person's daughter comes before the board for an expulsion. So it's usually in situations involving person's due process rights, the right to life, liberty, or property. And in a situation like that, or let's say somebody is your best friend, and you're got a matter coming before the board, maybe a contract. In those situations, if you again, you have the ultimate decision about whether or not to exercise that. I usually advise people not to vote in that situation because it does create the appearance of wrongdoing, but it is not illegal for somebody to vote in that situation. But personal bias can affect this, and there's a kind of a notorious case I'll talk about in a little bit here involving a land use strategy before city council, which I think is a better illustration of that. So it has to do more with knowing something about the specific people involved as opposed to just general belief. I mean, you might think that charter schools are wonderful, and therefore anytime there's a charter petition, boy, you're all ready to vote for it. That's fine, because that's a legislative matter. Whereas here you're voting on what are called quasi-judicial matters, which involve individual rights and individual, like student expulsion, right, their right to continue their education. In those cases, you have to step down if you think it'll, and again, sometimes you may hate the person too, and that's just as bad. So, again, in favor of or bias against either one. And again, this also applies to employees, by the way. So if an employee advises board members, this isn't as big a deal with the school district, but I think in some situations, board members may get advised by employees about things like contracts. That also could make them susceptible to consequences. This is just a list, by the way, we're going more depth on each one of these. And then the penalties, again, can be criminal, civil, contract can be voided. You have to give up the funds that you got, and you may forfeit your office. So there's lots of serious consequences for the conflict of interest violation. Much more serious in many ways than the Brown Act violations. Okay, this is 1090. This is California's contract against getting involved in matters where you have personal financial interests. So a member of the school board or college district shall not be financially interested in a contract made by them in their official capacity. And of course, this hits you all the most because you're the ones who actually vote on contracts. Nor shall district officers or employees be purchasers in any sale or vendors in any purchase made by them in their official capacity. So for instance, if the district is selling a car, none of you would be eligible to bid on it. An individual shall not aid or abet a district officer or employee in violating this. Again, employees are also, so Michelle, you're on the hook here just as much as they are. It's used in this article, district means, and it goes through this long list of public entities, of course, school districts are certainly included within this. California has much more robust good government statutes than the federal government. The Supreme Court in the last few years has really watered down the laws against open corruption. I mean, almost anything goes at the federal level these days. Whereas it used to be that people actually go to jail for this kind of stuff. You know? Okay, well, move this along here. Contract to hire board member number one's spouse. That the district's new architect is on the agenda. Can board member number one vote on the contract? No. You already saw the answer. Can the board approve the contract so long as number one abstains?
Yes.
No. This is one of these, like, I did this in front of a group of about 40 people down in Santa Cruz County, I think it was a lot of gas. Government Code 1090 prohibits the board from approving any contract that involves a board member or a board member's spouse, even if the board member abstains. There are these exceptions, remote interests and non-interest. We'll talk about a couple of examples of those. But generally speaking, the entity itself is aced out if any of their board members are involved. And like I said, I think this is one of the great misconceptions here. That abstention is always the cure. It is for almost everything. It is under the Political Reform Act, but it's not for 1090. And this is where sometimes people get bitten because they don't realize that just abstaining is fine as long as they're not on the board. Now, we've had situations come up, and I'll talk about that too, where board members, in fact, did have contracts with the board after they got on the board, and they have to go through this lengthy process to demonstrate that they're the only person who can provide a particular service or commodity. And that's very, very rare if you can do that. The board wishes to buy computers from an electronics company where board member number two's spouse works as the CFO, which offered the lowest price following competitive bidding. So you had competitive bidding, this was the firm that came in low. And the board award the contract as long as the board member's spouse abstains. And I put the fear of God into all of you. The answer here is no, and this is why. This is not considered a quote-unquote remote interest. Government Code 1091 has this long list of things that allow you to vote on a contract for certain situations. So, it's a contract that's bid, it's not for personal services. Now, let's check here. The spouse did not participate in the process. No information here to indicate that she was. The spouse is a low-level employee. That's the big one. She's a high-level employee with this company. And the other exception or conditions are the firm has to have more than 10 employees. They don't want a mom and pop, basically, when doing this. And the board member must abstain. So if all of those things can be demonstrated, then the board can enter into that contract. The problem here is she's so high up in the company that basically that company is now ineligible to even bid on that contract. So they shouldn't have even thought. And there's a whole long list of these statutes. There's 1090.5, there's 1091, there's 1091.5. A lot of my time is spent reading through these exceptions here when there are multiple part list of conditions, and then if you fit everything in there, then okay, yeah, you can vote on this, or the board can vote on this contract, you should still abstain. The board wishes to enter into a contract with a nonprofit corporation to provide educational support services. Board member number 4 is also on the board of the nonprofit. Can the board enter into the contract if number 4 abstains?
No.
I think based on what we've already heard, the answer should be no, but in fact, the answer is yes. One of the things I have to say about conflicts of interest is leave your common sense out in the hallway, because a lot of this stuff is so counterintuitive. Like I said about that last one, where the person, the first one, where the person is abstaining and law says that's not good enough. The remote interests include contracts involving nonprofits. The legislature has kind of greased the skids here for nonprofits because, number one, the person is not going to personally benefit from that kind of a contract as they would if this were a contract for a company that they owned. And second, I think there's just a general policy to try to encourage nonprofits and school districts to work together because they do provide a lot of services. So that's 1091B1, and then I have to put this in here. Compare People versus Honig. Is everybody familiar with Bill Honig?
Yes.
Yeah.
Superintendent of schools.
Yeah, he was convicted 4 felony counts of, his wife had some kind of educational support company, and of course, while he was the state superintendent of public instruction, she was going around shopping her services to school districts. And luckily for him, he was a Democrat, and Dan Lundgren was the Attorney General, who was a Republican, and they were kind of, so Lundgren went after him, and he was convicted, and he is now ineligible ever to serve in public office in California again, or elective office, I should say. He could still be appointed. I think Jerry Brown was thinking about appointing him to some state board, and I think Tony told him, no, don't bother. It just kind of comes with that, lingering bad smell. Okay, the bond director hires a local contractor, Smith Builders, to help with preparing bid specifications for a library project. Can Smith Builders bid on the job? Well, this one is no. The reason is that 1090, first of all, applies to contractors as much as it does to employees, because contractors have this financial relationship with districts. And even though they're quote-unquote independent contractors, the important thing here is that they hired this contractor to prepare the bid specifications. And then that person is going to turn around and bid on the job. And the problem is that there are ways that you can, if you know what you're doing, you can shape the specifications to make it much more likely that you will win the bid. And so if you participate on the front end, you cannot bid on the back end. So you have to make that choice. If you want the money up front for the bid specs drafting, then you can't move forward with this. There was a company years and years ago in the 80s when lottery tickets first came to California. It was called Scientific Games. And what they did was they put this on the ballot, but they were the only company in the United States that was prepared to print lottery tickets. And so you talk about a conflict of interest. But because the voters approved it, and they put these very short timelines for stuff to be, delivered and this and that, they were basically waiting there with their warehouse full of stuff to move forward if the voters voted up, and they did. And that was okay, though, because the voters put that in the ballot, so therefore that sort of laundered it for that. I think if this had been a different situation where they'd simply gone to some kind of body to approve these tickets, that wouldn't have been permissible. Okay, the district is searching for land for a new school site. Board member number 1 offers to sell the district property he owns at 50% of the appraised value. Very generous. Is this permissible as long as number 1 abstains from the vote?
No.
Yes, this is the example of no kindness goes unpunished. Thompson versus Call, legendary case. Hubert Call was a city councilman for Antioch or Piedmont, one of those little cities down in the Bay Area. And he had some beautiful hilltop land that he thought would be great for a city park. And so he approached the city and they said, well, we've got to, do this more at arm's length. So he sold it to a third party. And then that person sold it to the city. He got legal counsel that told him, yes, this was permissible. And then Thompson is the classic gadfly. He's off in the bushes there, and as soon as this thing went through, he sued. It went all the way to the California Supreme Court, and they said, number 1, he doesn't get the money, the $250,000. But he doesn't get the land back either. Isn't that nice? But he made this generous donation to the city of $250,000, which apparently was worth double that, because this was half value. So, yeah, it's, like I say, this stuff just does not make sense from sort of a common sense or everyday logic standpoint. The district offers to buy a different land at a different location. However, board member number 5 owns a lot next to the proposed site. Can he vote on the contract to buy the property?
No.
Maybe. It depends. With a very lawyer-like answer. PPC regulations regulate this. There's a 500-foot, there's actually a 3-tier, it's like a bullseye on the target. If you're within 500 feet, it is presumed to be a material conflict and you should abstain. Again, abstention is the remedy here because this is the Political Reform Act now. Again, he's not selling the land, he just happens to own land nearby. That's the important distinction here. Within 1,000 feet, then it is considered, basically it's presumed, but you can disprove that. And then finally, over 1,000 feet, the law presumes that there is no impact. Again, these are just arbitrary numbers that they picked, but when they wrote the regulations, the Fair Political Practices Commission decided these were the general standard. I've seen people there with a topo map trying to figure out what's the nearest corner of this property to the nearest corner of that property. Is it too close? This became a big deal when cannabis rules were coming in, you know, how close were people to this? And of course, they were required to be a certain distance away from schools and all that kind of stuff too. Okay, the Political Reform Act. We've moved on from Government Code 1090. And again, this one, abstention is normally the remedy. So, Government Code 87100. No public official in any level of state or local government shall make, participate in making, or in any way attempt to use their official position to influence a governmental decision in which they know or have reason to know that they have a financial interest. You'll notice that it says, make, participate in making, or in any way attempt to use their official position to influence. So there's really 3 different standards here. So it gets very far from just voting on it when it comes to the Political Reform Act. Board member number 3 is an accountant. The board decides to buy computers from a local firm owned by a private client of board member number 3. Can he vote on the contract involving his client?
No.
No.
Well, this is another one that's kind of one of those, it depends. It depends. If the client has paid income to the board member of more than $500 over the last year, then he must abstain because now it is presumed that his financial relationship with this person as a private business client will influence his decision. This is kind of like what I was talking about, although what the Political Reform Act has done is it has incorporated some of these bias things in there based on other relationships. If the board member, it's presumed that this decision will have a reasonably foreseeable material financial effect because he's benefiting a client of his who might then be more happy to do business with him as well. Also, was this business income disclosed on Form 700? The $500 better show up on the Form 700 or the FPPC is going to come around. Board member number 2's term expires. At the next meeting, he appears before the board to advocate for a special software contract on behalf of his client. Is this legal?
I would say yes, please, no honor on the board.
Surprisingly, this is what I was kind of surprised when I first noticed. No. This government code section, very long one. There is a 1-year ban on appearing before your own former board on behalf of third-party clients. They call this the revolving door rule. Washington has some of these anti-lobbying provisions like this too. Interestingly though, it does not apply if you appear on your own for your own, so if he's selling this stuff to the board, that's okay. Which I think is just, you know, bonkers, but can't represent somebody else, but you can represent yourself for the same deal. Okay, conflict of interest code in Form 700. I'm sure if you haven't already, you're going to have Form 700 in your future. In fact, they're distributed the 1st of February. So, the Political Reform Act requires that districts adopt a conflict of interest code, which is simply one that you get as a canned code you take out of Title II of the California Code of Regulations, and then you shape that based on what your situation is. So, it describes the designated positions. These are the people who have to file Form 700. Not everybody does, obviously. I don't think teachers normally have to file them. Some principals do if they have financial decision-making. Most principals, I don't think you can go that far. And certainly the superintendent, of course, is an executive officer who has all kinds of financial influence, has to file. You list a designated place and time for filing Form 700, which typically is just, Rochelle or whoever receives them for this entity. You outline the prohibitions, which is usually also in the code anyway. And then it's reviewed by the FPPC, and it has to be updated or not every 2 years, depending on whether there have been any material changes. The gift basket is delivered to the front counter of the district from a contractor who has completed a project. No individual is named, so the staff takes to the superintendent, who then shares the contents with the staff, as superintendents always do, of course. Must the superintendent report the basket if its value is over $50? It's a $50 threshold for reporting gifts.
No.
In this case, no, because it was not made to any individual. So as long as it was addressed to the agency and not to one person, and as long as no one employee receives more than $50, not this bottom of the line here, somebody's gotta take that home, The same gift basket is addressed to the superintendent, who then shares the contents in the same manner. Is that reportable?
Yes.
Yeah, in this case it is, because it's initially just a gift to her. In my general ethics, where we just spend the 2 hours on the ethics, I have all sorts of these kind of examples here, but this is the gift basket one is one of my favorites. And certain entities get, my office actually used to get boxes of candy every year, because one of our attorneys did a lot of litigation, and the court reporters, who have more money than God, used to always send like a big box of candy to him every year, because he was giving them a lot of business, so. I don't know if you ever reported that now that I think about it. Well, anyway. Other ethical topics. So we're off the Political Reform Act now. So again, perks, use of public resources and gifts. Fair process of decision making. This is the one about common law conflict, close personal relationships, or animus. Loyalty, incompatibility of office. If you're on a board and you try to run for another position, that may have an effect on your position with the board. Board member number 4 is offered $500 by the Chamber of Commerce to give a speech regarding local education. Can he accept the money?
Yes.
No.
Surprisingly, no. This is what's called honoraria. If you look in your handout there, I think you're on page 24, there's a list about honoraria. Honoraria means getting paid for giving a speech, and that is prohibited under California law for sitting elected officials. Can he accept the money if he directs payment to the school district? Probably. There is a process for the district to accept payments if the person tells the gift giver, or not the gift giver, the person paying for the honorarium, don't pay this to me, pay it to my employing entity. And then that's okay. They can accept it on his behalf and use it for the betterment of education and so forth. My favorite question here. Oh, do an escape. Thank you. Do an escape. I get it.
Sorry.
There we go.
But you could do
Oh,
best,
yeah.
you need to remove.
Yeah, that keeps coming up there.
Yeah,
Okay, great, thank you. Don't trip. Yeah. Slide. They take a tax deduction for the donation.
No.
No.
They maybe put this in here. You probably should not. Some of you might remember the old TV show, The Odd Couple.
Yes.
There's the fussy one, Felix, and the slob, Oscar. And one time there was an episode about they had a haunted apartment, and a big painting at the very beginning falls off the wall, and then they go to a commercial, and they come back, and the superintendent is there patching the spot where the painting had been hanging, and he's painting dark brown paint over this beige wall. And Felix is standing there, he says, doesn't exactly match, does it? And the superintendent says, were you planning to put this picture back up here? And he said, yeah. He said, so hold on. And Felix said, well, I don't know. He said, don't tell anyone. So, can you take a tax deduction? That's between him and God and the IRS? I'm not recommending that, by the way. Again, cool now. All right. K-12 board member wishes to run for an open board position in the community college district. This is the classic incompatibility of office. Is this permissible? Well, he can run. But if he gets elected, then he's given up his earlier seat. The problem here is that the college has county-wide jurisdiction. In fact, goes into Lake County first too. So any public entity in this county is also overlapping with the territory of the college. And there are potentially situations where your duties between the two entities might be called and I've seen this happen. And for that reason, as soon as you get elected to the other position, you have by law forfeited your former position and you should resign when you get sworn into your new position. You can be appointed to the local planning commission instead. That also has a conflict there. The reason for that is, this is government code 1099, incompatible offices. I actually ran through this situation just recently in another county. There was a person on the county board of education who was also on a local planning commission. Well, some of you may know about taking land out of zoning, where the school district wants to do something. They did this, for example, in Eagle Peak in Redwood Valley, when Ukiah Unified went through that process, they took that land out of zoning, so the county can no longer regulate what they did with the land. It was kind of a nice step in the process they didn't have to go through, because otherwise you have to get the county's permission to build a school. Well, in order to do that, to get it out of zoning now, they have all these additional requirements, one of which is the proposition that you're gonna take the land out of zoning has to be reviewed by the planning commission of the entity that's involved. So if you have overlapping territory between planning county or city that has that planning commission, then that would be incompatible and basically you lose your job for doing that. Or in some cases, we find them already serving in both positions. We tell them, you gotta resign from one of these like tomorrow. And otherwise you're gonna be potentially getting, you can get sued by the Attorney General's office, which is called a writ of quo warranto, which you don't wanna be sued for. Okay, can a board member vote on a contract to hire their adult nephew as a district employee?
Yes.
Yes.
Now, hiring of employees within the third degree are prohibited under the education code. Here's the code section. A member of the governing board shall abstain from voting on personnel matters that uniquely affect the relative of the member. Purposes of this section, relative means an adult who is related to the person by blood or affinity within the third degree.
So 3 of the board members have relatives that work for the school district.
That can create
One a
problems.
husband, one a brother, and one a daughter-in-law, so.
So yeah, they would not, well, with the spouse, it would, yeah, that creates problems like if you're gonna vote on a pay increase. If it's for the entire school bargaining unit, that's okay, because that doesn't affect them any differently from how it affects other people. But if it's like a promotion for that employee, that person would not be able to get promoted while their spouse is on the board, because that affects that person only in that situation.
So it would have to be specific to that
That's restarting.
employee.
Okay, well, it's a question. Okay, so, you know, you can't do it for nephew because it's nepotism. Okay, I think we should say you go to, say, cousin or a second cousin.
Ah, I'm so glad you asked that. That was gonna be the next slide.
Let me see if I can come back.
Thank you, Jim. The whole reason I do this is because of this next slide.
Okay, I hope I didn't ruin the surprise.
Oh, no, you did. That's a very good question. I get these questions very early in the presentation sometimes about, you know, hiring relatives and promoting them and so forth.
If you wanna use the PowerPoint, it's updating
Oh, it's
right
not-
now.
Oh,
Unless you wanna go
No,
to the
wait.
slides because everyone
That's
has the slides.
I know, but they're very hard to see at this
Okay.
level, so that's fine. 98% there. Give you a half hour.
100%.
I love the way Microsoft just decides for you when you're gonna update it, whether you want to or not.
Oh, okay.
It's restarting again.
Okay.
You'll call one of the IT guys, I guess.
No, it's just an update.
Just wait.
It's just, I mean,
It's still thinking.
we have a few slides, we just use that.
Yeah, but I think this one in particular I like to put up here for,
Yeah, but okay, let's see.
here we
Now
are.
I gotta go back to the whole thing. So it was under, your
It's just on
PowerPoint.
his, he has.
It's on the
his
flash
drive.
drive.
His flash drive's still in there.
It says Lexa. Oh, there we are. Okay, we're back.
Is that, let me find the slide quickly. Oh, gosh.
That's okay. That's okay.
No, it's gonna. Some
I can find it. for you.
Okay. It's not.
Oh, I have to,
Okay.
there you go. Okay. So, Education Code 35107, that's the third degree, and then Attorney General's opinion. Now, what is the third degree? This is the question most people have, like, third degree. Well, this is the third degree. My very own little chart here that I created. It's very hard to read in that form, but if you want a color copy of this, I can certainly provide each one of you with this.
Please.
Love one.
This is you. These are actually normally used to find heirs of deceased people. So normally say deceased person here. But the way you calculate this is, you are in this box here, you're zero basically. And then your children and your parents are the only ones who are 1 degree away because, obviously. And then brothers and sisters are 2 degrees because the way this works is you go to the nearest common ancestor and then you go down. So for instance, you go up to your parents and then down to your brothers and sisters, that's 2 degrees. Nieces and nephews are in the 3rd degree. So anybody that is close, and that includes grandchildren, great-grandchildren, grandchildren, great-grandchildren, children, grandparents, grandparents, and then as you go over here, aunts and uncles, and I think that's all it for the 3rd degree. There's this belief that the children of your first cousins are your second cousins, and that's not correct. They are your first cousins once removed. True brothers and sisters, are the same generation as your brothers and sisters, your first cousins, second cousins, third cousins, and fourth cousins, and so on, are all in the same generation. If we get to these folks out here, I mean, you have to go back to multiple generations of other relatives. In addition, the people on this line and this line, at the top of the stair step, are called lineals, because they are the people either without whom you would not be here, or without you, they would not be here. Everybody else on there, including your brothers and sisters, could easily exist without you. So, they are all called collaterals, and they are somewhat more distantly related because they're only related to you through your common ancestor. So, all right. While at an education conference, the board president is invited to a school finance workshop and then to a Warriors game. A financial advising firm, Smith Consulting, is paid for the ticket. The board president is best friends with the owner of that firm, Patty Smith. Should the board president go to the basketball game?
No.
Sure, why not? Should he pay for the ticket? That's why we're here.
Okay.
Yes. Question here is, you probably should pay for the ticket. Again, the gift limit right now is $640 from one source per year. And every gift over $50 needs to be tracked and reported on Form 700. So, and again, we have these colleagues, which apparently are true, where people just start handing money to people who are, of course, politicians, and so therefore they're not expecting anything for that, I'm sure. Should he vote on the upcoming contract to hire Smith Consulting to represent the district regarding an upcoming
No.
bond? Yeah, this is the problem here. Patty Smith is his best friend, so he should not vote on that contract. Because, again, you could say, I can honestly say that my lifelong friendship with Ms. Smith does not influence my decision to vote for this contract. And if it's like a 5-0 vote, I'm not sure there's any harm. It wouldn't have made any difference if you confused yourself. Nevertheless, I usually advise people in that situation to refuse and, again, to avoid the appearance of impropriety. Okay, a software vendor is proposing the district buy its new educational software. The firm offers to pay for the superintendent and the board president to fly to company headquarters in Boston to meet the software designers and attend a workshop on the virtues of the software. Is this permissible?
Yes.
Unless the plane tickets don't exceed the $640 gift limit. No, and of course, they'll probably be paying for hotel and everything else, like meals. So, we actually had this big scandal some years ago. I think it was Caldwell Floors, one of these firms that advises on bonds, like in the last example, had some sort of person go rogue inside the organization, and they had been giving Warriors tickets, superintendents up and down the state, in thanks for their, good working relationship. These tickets are not cheap. And we had one superintendent, I remember in Sonoma County, who must have gotten like $1,000 worth of these tickets over the course of a year. Well, the FPPC then took that register that this person gave him and they lined it up with the Form 700s, and this person didn't report this ticket, and this person didn't report that ticket. It was very simple for the FPPC with this list to go back to check individual Form 700. So, the superintendent at one of the districts down in Marin County was fined $1,000 for this. And you still have to pay back any money that exceeds the gift limit, by the way. So that's exactly what happened. I called the FPPC and I said, we have some superintendents here who are kind of concerned about this. And I said, because first of all, they hadn't reported this on Form 700. So I said, if they file an amended Form 700, will that do good? She kind of laughed and said, yes, we look upon that as a sign of good faith. And they have to repay any money that exceeded the gift limit for that year. So in those days, it was a lot lower. It was like $460. But they were handing out this stuff like it was confetti. I mean, it was just amazing. And so, yeah, it's always good if you get any kind of a business associate, it gives you something to report that. And this FDPC publication, I think it's on page 24 of your handout there. It's the list of honoraria, and maybe that's not the page, I don't know. No. Oh, yeah, you're right. Excuse me. That's okay.
I think 30.
Oh,
31.
thank you. Yeah, 30 and 31. This is the, there's a section there on honoraria too. Yeah, this is the face page. This thing has 14 pages in it, so I didn't reproduce the thing because you can download these from the FPPC's website, and I figured why thicken this thing out with paper that you probably will never look at again. But I'll tell you, they will give you every conceivable factual scenario about what is and is not a gift. They talk about wedding gifts and so forth too. It really gets quite complicated. So, on the flight home, the board president is given a free VIP upgrade to first class by the airline in honor of his illustrious position. Should the board president refuse the upgrade and stay in coach with the superintendent?
No, we shouldn't.
Yes. If you accept free or discounted travel from a common carrier, you lose your office.
Wow.
This goes back to the 19th century. The railroads controlled California in those days, and they used to give free travel to members of the state legislature anywhere in California, which was a great perk in those days. And the governor at that time, Hiram Johnson, ran through this provision of the state constitution, Article 12, Section 7. It would also violate the gift limits, just as a possibly as an aside. But the big problem here is that he's getting an upgrade because of his position, not because he paid for it or because he's like a member of a frequent flyer club or something. And the legislature still has that that's still in the state constitution to this day. Some years ago, when the skunk train was revived for the first time after 25 years, they were gonna have this big celebration. They invited all these public officials to come and take this train. In those days, you could go all the way to the coast on the skunk train. And somebody said, what trip they're gonna take, doesn't it have something to do with that thing in the state constitution? So we started making all these frantic phone calls saying, don't get on that train. Or at least if you do, buy a ticket, because otherwise, potentially you're gonna be out of a job the next day. So, and again, you'd have to be sued by somebody to force you out of office, but this will work if it actually is in effect, so. Oh, another thing popped up here. All right, so, like the early one, right back to this. So, that is the conclusion of our presentation. Does anybody have any other questions? Anybody still awake?
Yeah.
Well, thank you all for your time and attention. I apologize for the glitches here about getting started, and some of these computer things here, it just happens sometimes like this. Actually, this isn't bad compared to some of the other. I mean, one time I showed up and they did not have anything ready to do anything, so I had to do the whole thing standing there holding the little tackle. So this is much better, at least in my opinion.
We appreciate your expertise.
Oh, thank you
Yes,
very
thank
much.
you.
Sharing it with us.
So it's nice to see all of you. I know at least some of you. We go back and we go back, so. All right.
Also, I did have a question for you, sir,
Sure.
slightly related. I have a friend who's actually on the school board of a larger district. They actually get a stipend. How are they, how are they determined, who determines the amount of the stipend? Since I'm assuming that they can't vote for it themselves.
It's actually, well, you do vote for it yourself. It's in the education code. Boards can award themselves a stipend. They just raised them, in fact, too. So some of the districts are anxiously awaiting the anniversary of the last time they did it so they can bump it up. But yeah, it's in the education code, there's a kind of stair step. Small districts get very little, like $240 a meeting or something like that, or a month. And then larger districts, it goes up, but it's still not, I mean, the boards of supervisors and the city council can pay themselves whatever they want. And that's where that big scandal came down in Southern California years ago, the city of Bell, where they were paying
Oh,
themselves
right.
tens of
Huge
thousands of
salaries,
dollars. Yeah. Whereas, this is very carefully regulated. The board it can choose not to, but it can choose to, again, this is kind of one of those controversial issues, right? You wanna face the voters again after you've just voted yourself a pay increase. But, safe thing to do is you put it like 5 years down. You just hold your breath. But yeah, it depends on the size of the board, I'm sorry, the size of your ADA, so, yeah, that's,
Well, this is a district in Southern California, I think it's got about 10,000 students.
yeah. So they can get paid several $100 I guess, either a meeting or a month, whatever's in the code. And you can take a look at that and, maybe somebody wants to bring that up and you can discuss that, because again, you are just donating your time at this point. So, I mean, some of these small districts, the stipend is so small, I mean, it's basically just enough to compensate you for, car fare, but at least, it's something. And do you get any kind of benefits like healthcare in
No.
the district? Yeah. Some districts also will give board members health coverage, so,
The district used to, a
They
long,
did,
long
yeah.
while back.
yeah. So, but again, you actually are the ones who vote on that, though, nobody else. I mean, again, first of all, it's subject to referendum, so that voters can put it on the ballot. And again, they may retaliate against individual board members in some cases too. I think the money is so small, it's really not, I think a critical issue for a lot of voters, even though, but again, sometimes it's the symbolic effect as opposed to the real, so.
Well, they did just change that rule. I
Yeah,
think
they-
the max went to $1,250 or something.
Yeah, I mean,
You're not gonna get well paid.
no, that's the whole thing. I mean, nobody gets well used. They're actually following the rules in this business, so. But, yeah, I think it's a little bit of an acknowledgement. We used to pay the planning commissioners $20, I think, just
Yeah.
token things. And I remember one of the planning commissioners even said, he said, for the amount of time I have to put in on this, he said, you could not pay me enough. He said, that's why this is basically just volunteer work, so I'm sure that you all feel like that too. You put in a lot of time in these jobs.
Okay, so we have lunch in about 15 minutes, but we have a couple action items.
Okay,
If
well,
you-
I will step down and, just check what I say. Oh, yeah, you might wanna take that back.
And Jeannie, don't forget that we
Right, thank you.
No. I don't know if I should just pull it out or,
I think put it as fine.
Okay.
Yeah.
it might affect it.
you want to say you're welcome to, or,
This charger is in mine, or is it coming from,
I'll grab it for you.
Okay,
You can let me know.
okay.
Item number 4, action discussion, or item A, public comment. Are there any public comments on agenda item? No, we didn't do that. Are there, 2, are there any public comments for items not on the agenda?
You actually can't have one of those, so it's a special meeting.
Okay. And we have your public. Yes.
And members of the public always have the right to comment on each.
Right.
That's it.
Okay, number 5, discussion, review and discussion, we did that. 6, approval of district vision, mission, and belief statement, version 1. And I want to say that the board needs to take responsibility for at least having a vote by the end of this board meeting on having a vision, mission, and belief statement, because the principals in the district are waiting for the board to make a decision so they can share it with us. Okay, so approval of the.
Can we open them? Can we open them first?
We'll open them. motion to approve version 1, is that what I, okay.
Does anyone have a strong view?
You need motions and then open it up to discussion.
Okay, again, can we just have a minute to read through it before we vote on it?
Well, I think we have to approve we're not approving version 1, but we're approving it as an action item, right?
Yes, you guys need to have motions on the table, so you can open it up for discussion.
So do I have an approval,
I move to approve.
a motion to approve the district vision, mission, and belief statement version 1?
I move that we approve the district vision, mission statement version.
Second? Okay. All in favor? Aye. Opposed? Okay, so are there any comments or,
I have a question.
I have a question.
okay.
My question is, does anyone here have a strong feeling in favor of either version or version two?
Yes.
I did last time that it was brought up, and I don't remember which one it was. I have not been able to read really well,
Okay.
so that's why I'm asking for
Cool.
time just to scan them.
Absolutely.
And I have a question on process, so go ahead. What confuses me is if we're gonna approve or not, number one, and then approve or not, number two, we can run into the same issue we ran into last time.
Except then we only had 4 board members, not 5.
Right, but if 3 of us say, yeah, I like 1, and yeah, I like 2, I mean, we're given the opportunity to vote twice when it's like this. And if there were theoretically people who liked both of them just fine, and we're voting on both of them as opposed to it being set up to say, do you want 1 or 2, those in favor of 1, those in favor of 2, you're gonna get a decision right away, it would seem.
This is the third time it's been on the agenda. The first time was a discussion. You guys had 0 discussion, so it was brought back as an action item, and then it died because there was no majority vote. It was emailed to you guys, and only 1 board member provided the input for us to even come up with 1. So now the 2 are on there for you guys to take action on. So the idea is that you would vote for 1 and not the other, if that's what you wanted to do. You wouldn't vote yes on both
Right,
of
and
them.
if you, that's my concern, if you want to vote yes for both of them, you're gonna have a potential for a problem. It would just
Why
seem
would you
to me.
why would you vote yes on both of them?
If
you
either
prefer
one of
one or
them
the
is
other?
just fine for you, then that's sort of where you end up. It just seemed odd is all, and to me brought up a whole lot of, holy cow, you know.
For my sake, I would say, once the vote, I need to have this to be passed today so I can do my work. Because I was.
Right, and I would hope
So,
that you don't get a tie, I don't know, I mean, I just,
Because the principals are waiting, and so it's very critical that
Okay, I'm ready.
for the support of the district and principals, we need to pass some type of vote today.
Does anybody else need time to consider version 1?
I'd also like to know up there, since John wrote these all up, with the input of the people who chose to give input, is there any way that, you know, you can sort of give what it would look like to have any of this? I mean, you know, what you envision as the way it would, a way that a school would explain each of these issues? Or just 1 or 2 of them in general? You know, like continuing growth on vision, version, whatever, 2. On version 2, there's a thing that
Oh,
says,
wait, what was still version 1?
We're discussing
sorry,
version
let me
1.
give an example of version 1. The high level of our teacher's ability. Well, can we get like an explanation of the standard for that? I mean, our district has people that are fresh out of nowhere, and others that are in the middle of programs, and others that have credentials that aren't yet completed in the sense that they need to work or finish a few more units or whatever. Our district also has people with full credentials in 10 years, people with masters, we even have doctorates in our teaching staff. And so I have trouble understanding what is a high level of our teachers' ability. Like, that implies to me that we have a baseline, okay, we don't hire people below that. And I would imagine your high level goes to the sky, it shouldn't make a big difference. But I mean, is there any of that you'd like to choose and give us a kind of like a more concrete example?
Well, I can give you some example of how
Oh.
teacher ability is. Typically, just like first, is to ensure that our teachers have the ability to teach efficiently in the classroom, so that it is the district is working on, to find professional development for the teachers over the summer and incoming as well, so that they have instruction support and how to teach, and so that's what we're working on. That's the ability I'm talking about.
Oh, okay, I thought it had to do with credentials and
No,
things.
not
I didn't,
credentials. No, not.
oh,
This
okay.
is the support to help the teachers to get all the support, professional development, and so they have the ability to teach in the classroom efficiently with all the tools.
Okay, then probably the high level of staff involvement is like site-based decision-making? Or are you thinking of committees or whatever that,
No, it's within the staff meeting. It's just that for the principals, that it's good for them to have the decision of to have the staff to provide input, like we have staff provide input on the reading 180 versus Lexia. That's an example.
oh, okay. Okay, and how would judging of a trusting relationship across the district go? Is that like high or low morale, or grievances and not, or, I mean, how do you judge that?
It goes along with on how, it's the school culture, it's the work with the principal, the admin, and the teachers.
Oh, okay.
So there's a similarity in content between version 1 and 2, but there's a difference in terminology, a difference in vocabulary that's used. So if you're not comfortable with the terminology at the high level of our teacher's ability, you could look over to version 2 and read the same item under belief statement in version 2 and see if you're more comfortable with the terminology there.
Well, I kinda did, and that's, for me, a deep respect for the knowledge and dedication of our educators is a whole lot different than their skill level. And those were the things I ran into, and that's the reason that I'm asking, because obviously I need clarification then, but okay.
So are there any other comments or questions in regards to version 1? So all those in favor of version 1?
Aye.
Opposed? Aye. Abstained? Nope. So, then we go on to approval of district vision, mission, and belief statement version 2. So do I have a motion to approve that action item?
I make motion to approve that
I
action.
second it.
Okay. All those in favor?
Aye.
Aye. Opposed?
Can we just say, can I say something first, though?
Yeah.
I think we have to approve it first.
And we can
I mean,
open it up.
approve it being an action item.
Oh, okay,
And
yes.
then you can
Okay.
comment, okay? Okay, so we're approving the,
No, you get a motion, then you open it up for discussion, and then you take a vote. So you guys have a motion, so you can open it up to the discussion.
okay,
I
so,
just wanted to say the reason why I prefer number 2 to number 1 is in the belief statements and in the vision. We envision a vibrant learning community where all students are inspired to discover their potential and supported in becoming confident, capable, and compassionate individuals. It talks about the child and the child's finding of themselves, which the other one doesn't really do in that sense. And that, for me, was the overwhelming piece. So that was all I wanted to say.
So I like version 2. What I did is I set both version 1 and version 2 right next to each other. And then I read one section, like about us in version 1. And then I went to the same section in the version 2 and read that section. And I did that throughout the 2 versions. And I prefer version 2 because I like the way it's formatted. There's a lot more white space, and to me it's easier to find information. And I generally like the terminology more in version 2 than I do in version 1.
I'm in agreement with that. I like the terminology in version 2 better than I do in 1. So that's why I'm going, yeah.
Yeah, essentially the same. I mean, again, it's very subtle, you know, different, very subtly different meaning, but I thought 2 was a little bit more where I thought more,
To the point.
yes.
Yeah.
Any other comments? So all those in favor of version 2?
Okay.
Aye. Opposed? Okay. And then we have the approval of the school accountability report card for New Horizons, which was, so do I have a motion to approve the school accountability report card for New Horizons?
Okay, I'm, oh, sorry, go ahead.
Okay.
Okay, I'm that we approve the accountability report for New Horizons.
I second.
Are there any comments or matters to discuss? No? All those in favor?
Aye.
Aye. Opposed? So now we adjourn the meeting, yes?
Wait,
Okay.
do we need to adjourn the meeting since we don't have lunch here?
So the special meeting of the Willits Unified School District Board of Education that was held on Thursday, January 15th is adjourned.
Thank you. We just want to talk about it.